before I get into this other line of questioning, maybe you could just hop in real quick, because I know people are always curious about this. And that's, is it a gating issue for receiving, for getting your money, Karl?
I go back to, I think, as long as you have the strategy, right? In biotech, life sciences, yes, because that is the asset. And if the world ends tomorrow, at least I can walk away and I can leverage that asset as a remaining asset and maybe get some of my money back. But in a medical device, you may not have the patents filed, but you have a strategy to get there. And again, I'm going early stage. I would expect by a Series A that you have it figured out and probably some provisionals filed. Seed, friends, family, and fools, I think it's fine. But certainly when you get professional money in, and I usually say that my money is not professional, professional money. So I would say that some of my seed investments are even without a business plan, right? But you have an idea, you get the people around the table, you have the vision, you articulate that business opportunity and how to get there. But certainly by, Series A, you would want to have that.
I guess I'll just chime in once again. Like if there's an example where I had a fair number of people in Vermont, which is not hard or not very often it happens. They're all kind of cheering for RENOUN and ready to throw a check in. And because the IP was not granted, because we just basically had enough time for that to process, every single person pulled out because it hadn't filed, it hadn't been granted yet. So in that case, the IP was there, but it wasn't, the final check wasn't checked off, and we completely had to downgrade or change our plans for the next 3 years. We were pretty close to the signing table or something like that. So it was a tough change, but I mean, looking back on it, it was the right one to happen. But just for reference, that happened to us. So.
Yeah, we had, I guess, something similar to that where from an IP scenario, we interviewed investors at early stage. We're less than a year old. We interviewed somebody as an early stage investor, and they were so impressed that we had negotiated the rights to the IP that the conversation about investment accelerated to the point where that person ended up basically just asking if they could work for free for the business. It was sort of they were so interested in investment, they were like, wait, you mean I can just come to work here and work on my invest? It was just like the enthusiasm, momentum of that scenario. And now that person who had sold their strain gauge processing company for 5 years prior and was essentially in retirement at that point, it came out of retirement is basically working in our lab. And that conversation started with, hey, you want to invest and we own all the IP, and it was just like this snowball started gaining momentum from that discussion. So it definitely makes a really, our experience has just been that having to your point of having a strategy, no, do we have the patents filed? No. But having a strategy where a client has given us ownership and there's the pieces, the pathway is laid out, has definitely helped.
Sure.
And the patent law firm, the patent attorneys actually can play a role in that and at the exit point as well. Because there might be a third-party patent law firm coming in that the investors or the acquirer hires. Who are they going to talk to? Yes, they're going to talk to the entrepreneurs and the CTO, but they're also going to talk to your patent counsel. Mm-hmm. And you can rely upon your patent counsel to get your back and to articulate. And because now, it's a different language, right? It's kind of esoteric. And to have your patent counsel being able to go to bat for you is valuable.
Thanks, guys. I appreciate that.